Members, we have formed a quorum and reached the appointed hour, so let's get started. First of all, members, I would like to inform members that Ms. Claudia Mo wrote to me on the 19th of November 2015, informing me that he would withdraw from this panel. Item number 1, information paper issued since the last meeting. CP 4246/1516/01, which has been issued to members, is from the administration wing of the CS office on the review of laws and provisions which have yet to be implemented. And that is to say that these are provisions which have yet to commence for over 3 years. It's a list. Members should have received and noted the paper. Questions? No? Okay. Item 2. Items for discussion at the next meeting. For items for the next meeting, we are going to have proposed legislative amendments to implement the final phase of 5-day week in the judiciary. And the second item, bilingual legislation drafting. Members, do you have questions? All right. We have received from Ms. Alice Mack a letter from Ms. Mack. Let me find the letter. It's dated the 18th of November 2016. Requesting that this panel discuss the terms of conditions and terms of employment and conditions for the part-time interpreters of the judiciary. He would like to put this on the list of items for discussion. So what do you say, members? Any objection? No? All right, so it will be put on the list of outstanding items for discussion. Item 3. We need to spend some time on this one, 2015-2016 Judicial Service Pay Adjustment.
OK， 好彩秘書就同我講咗。
Luckily, I've been reminded by the clerk that we have referred a number of items to other panels. First is from Mr. Alan Leung. The criticisms from magistracies on the abuse of power of the police. As the matter is a police matter, it falls under the terms of reference of the security panel, so I have referred the matter to the security panel accordingly. Deputy Chairman, well, first of all, I agree that law enforcement falls under the ambit of the security panel. Later, the Director of Public Prosecution will come here to talk about publication and the adducing of evidence in response to some criticism from the courts concerning the evidence provided by the police. and we will be able to take a look at the prosecution-related matters. I've been reminded by the clerk that this will be discussed in the second or third quarter. Ms. Anne Zhang has proposed an item on how to deter people from insulting the police, as this is also a police matter, and therefore it comes under the terms of reference of the security panel, so the matter has been referred to that panel. And please also note that one of the items, outstanding items for discussion of the security panel is on the training, psychological training of police officers. And they would also take up the proposal to legislate on the prohibition of insulting the police by citizens. They will discuss this in the second quarter of 2016, and also in respect of the proposals from the Hong Law Society to Section 4B(2) to the Legal Practitioners Ordinance, and also Foreign Lawyers Practice Regulation Section 8(4). As the amendments are minor, so they have been deleted from our list of outstanding items for discussion. Ms. Anne Zhang has also proposed an item on sentencing policy. Well, the judiciary has advised that this comes under the discretionary power of the judiciary, which is independent. Therefore, it's inappropriate for the judiciary to send anyone to attend our meeting when we have a discussion on this. As a result, this item has been deleted from the list. And Mr. Dennis Kwok has proposed that we should examine the duty lawyer scheme provided to the claimants, to the various claimants, as this will be followed up by the security panel. It has also been deleted. Mr. Porcher has also proposed an item on bail, granting of and refusal of bail. This arises from an independent or individual case, so it has been deleted from the list. And also on the covering of IPCC by the Ombudsman's terms of reference, as the IPCC is not agreeable on their being covered by the terms of reference of the Ombudsman, and no one has asked for any follow-up action since 2011 from members of this panel. So we have also deleted this item from the list. So that's a number of items. That's in relation to a number of items which have been deleted from the list of outstanding items for discussion. I want to remind members that in accordance with paragraph 83A, or Rule 83A of our Rules of Procedure, if members have any direct or indirect pecuniary interest in relation to our discussion items, please disclose the nature of your interest before you speak. We now move on to item 3, 2015 to 2016 Judicial Service Pay Adjustment. The relevant papers are CSO ADM CR 6/3221/02. The paper was distributed to members on the 29th of September 2015. Another paper is a CP4 226/1516(03). It's from our Secretariat, a background brief. The paper has been issued to members. I would like Ms. Kitty Choi to walk us through the proposal. We are now here to discuss the annual pay adjustment for judges and judicial officers. Annually, the CE in Council would make reference to the Independent Standing Committee on Judicial Salaries and Conditions of Service and make adjustments. This year, the government has accepted the Judicial Committee that for 2015-2016 there should be an increase of 4.41% in salary. We are satisfied that the Judicial Committee has fully taken into account the basket of factors agreed by the CE Council in 2006, and also have regard to the maintenance of an independent judiciary and the position of the judiciary. The list of 12 factors are set out in paragraph 33. So I won't elaborate now, but I would like to talk about 4 aspects in respect of the factors considered by the Judicial Committee. First, in relation to the recruitment and retention by the judiciary, the Judicial Committee has noted that in respect of the recruitment of CFI judges, they encounter difficulties. Therefore, the judiciary has been doing something about it, and that is they have compressed the exercise from triennial exercise to a biennial exercise for CFI judges recruitment, and they are also reviewing the terms of employment and also the retirement age of judges. The 2 reviews are conducted in order to attract quality legal practitioners to join the rank of judicial officers and judges at the later part of their career. And there's also a benchmark survey which is conducted once every 5 years to gauge the gap, the movement of the changes in the pay between the judges and judicial officers and legal practitioners, so as to provide reference for the 2016 pay adjustment exercise. This time, when the Judicial Committee looked at the pay and terms of employment in the legal sector, as there's no representative survey, the Judicial Committee only look at the gross indicator and then deduct from it the increment-related part.
And after making the decision, the index is 3.9% positive. And another area that the committee would take into account is inflation. In the past 12 months ended March 31st, 2015, it had been 4.5% in terms of inflation. Pay attention to the index that this is higher than the 3.9% as in the salaries index that we mentioned earlier. And also the committee had also taken into account the public officers in the 2015 civil servants annual salaries review results, and that is to say for the net index, they have added a 0.5% to it. But at the same time, the Judiciary Committee had not reviewed or taken into account the once every 6 years salaries standard or salaries level review. If you remember, the Finance Committee had passed that for master's pay scale 45 points or above, that is senior officers and directorate senior officers, there can be a recourse to October of last year with a 3% increase in their salaries. Now, the Judicial Committee is of the opinion that the 5-year round judges and judicial officers pay review, to compare that with the current review results would be more appropriate. Therefore, they have not taken this 6-year review of the civil service pay into account. And at the same time, the Judicial Committee had also taken into account the stance of the judiciary, and the judiciary had given us a view of 4.41% for judges and judicial officers. So that's 3.9% plus 0.5%, and they are of the opinion that if this 0.5% increase is not put into the pay rise, then it would fall behind the private practice for judges and judicial officers. So the committee, after taking into account the recruitment and retention, inflation, and also the trend for private sector pay and also civil service pay revisions, all these factors plus the 8 basket factors that we have mentioned in the paper, then this year there is to be a 4.41% raise for the judges and the judiciary officers. And it is a 15,910,000 Hong Kong dollars. And if this is passed, we will bring this to the Finance Committee for approval. Members, any questions, please? Kwok Wing Hang. First of all, this 4.41%, I see that the inflation rate is 4.5%. This falls short of the 4.5%. I'm sorry, 5 minutes Q plus A. All right. 4.41% is a proposed level, but in fact, the inflation rate is 4.5%. This actually falls short of the current inflation rate. And another point concerning the recruitment of judges, there is still big problems there. The vacancy rate we have been talking about for a long time, and it is still 11.9% in terms of the vacancy rate, and the pay can never be commensurate with private practice lawyers. So can we think of perhaps raising the retirement age? Is there any new developments in terms of that consideration and on the judiciary side? And another point concerning the workload, the judiciary had also noticed that in the writing of judgments, the amount of papers that they have to refer to is increasing as well. This is another reason why there is a recruitment problem. And this is something that the judiciary has to pay attention to as well. So these 3 points, would the administration please respond to them? Thank you, Chair. Thank you, Mr. Kwok, for the question. Actually, since the unpegging of judges' pay and the civil services, we have been looking at the basket factors, and there had not been a fixed relationship between the inflation and the pay rise. In the past, it had been, even though the inflation had been higher than the net index, it had nevertheless the pay rise had been lower than the inflation rate. It depends on the stance of the judiciary and all the current year's net index, etc. Now, the vacancy rate just now, it was mentioned 11.9%. And the retirement age, whether that can be raised for judges, that was a question raised just now. Now, as I started the meeting by saying, in order to recruit more experienced judicial personnel into the industry or profession and to serve as judges, we have started an exercise whereby the retirement age of the judges can be raised. We've started that study. Now, concerning this study, the latest development is that consultants have been appointed to conduct studies for different levels of judges, but the study will take time. Once completed, the study and the results will be shared with the government. Mr. Chair, can we ask for the judiciary, in terms of raising the retirement age and also the workload review, what stage of work or progress is it at? because the committee had been discussing that at length and for a long time, can we not ask them this question? Because otherwise it is a very sorry situation. As you know, the standard of legal protection is undermined because of the vacancies of the judges. And also talking about manpower, resources, and the judicial assistance program, that is assistance to the judges. Can we extend that further? All these are issues that we have discussed at the committee. So you're saying it is insufficient, right? The Supreme Court, the 5 and the 8, that's correct, Mr. Chair. Even though there are these assistants at the High Court and at the Final Court of Appeal, but in fact the overseas experience had been more extensive. It would provide assistance to the judges, much needed, and also opportunities for younger lawyers to work. And perhaps this will also attract more judges. I do not know whether you'll be able to answer that question. No, perhaps not. What the information I have, Mr. Kwok, you would probably have that as well, and that is at the final Court of Final Appeal, there are 5 such assistants, and also there are 8 in the appeal court. And this is information which Mr. Kwok already has. Perhaps we should send a letter to the judiciary to find out? Yes, good. Now, also, the pay rise falls short of the inflation rate. Now, this is a problem. I know it's been done before, but it's still a problem. I'm second in line in questioning. Now, you mentioned just now about recruitment problems. Now, I'm looking at paragraph 4 in the paper. It says that there had not been major issues in terms of retention. And overall speaking, the conditions and pay for attracting those who are interested or elite who are interested in joining the judiciary, it is still attractive. That's what paragraph 4 says. I would like to know, paragraph 4, which paper are you referring to? I'm sorry, I'm looking at the reference material. I don't know which paper this is. CSO stroke ADM CR 6322-102 Legislative Council brief. Do you have that? It talks about the recruitment and retention of judiciary officials. Well, I don't think our pagination match, but that's fine. The actual situation is that for the judiciary in 2014, all right, hold on. That's the background brief. I'm so sorry. I would like to know in that case, for the net pay rise, the 3.91% plus the 0.5%, I know that the committee had already accepted this. I would like to know this 0.5% at the time when it was given to the civil service pay rise, it was to incentivize the civil service and to enhance their morale. Is that the same? Is there a similar need in the judiciary? That's my question. Thank you, Mr. Chair. Now, for the committee, they look at the entire civil service and the magnitude of pay. So that would be 0.5 plus the net index. But the committee had not looked into whether the 0.5% in the civil service, what purpose it serves, what background it is. So the overall consideration, as I've mentioned, is recruitment difficulties, inflation, and also the stance of the judiciary, plus the commensurate level, that is the matching. These are the factors they take into account. Hon LegCo next. Mr. Chair, I was supposed to. The chairman should be the last in line. You shouldn't be the second in line. In terms of questioning, this is not pinpointing you as a person, but this is what should be, so I'm raising this. Well, thank you for your point. Yes, well, I have never paid full attention to this issue of judiciary pay rise, because if you want to make money, well, become a counsel, barrister. So those who serve in the judiciary are those who want to serve community. That's what I think, because they have a very important role to play in terms of checks and balances. And because there's nobody to check them apart from public views, no one can check them. Now, what is the problem now in Hong Kong? I personally feel that a lot of lawyers, barristers, solicitors, they feel that there is no glory in serving as a judge. Why do I say that? Now, I also am one of those who have been poking at the positions of the judges. So in that sense, I'm also leading in the criticism of judges. Now, I am a LegCo member. I have to rely on my colleagues in order to make a decision. However, the chief executive of Hong Kong, or the senior officials of the Hong Kong government, including Mr. Yun, they have this public. They have this power.
And if they are they're always saying things about judges, well, it's going to exert a lot of pressure on judges. Mr. Andrew Lee, the former CJ, said that in adjudicating the court cases, the court can say that the CPG has acted unconstitutionally. It's not a question of the standing of the court in question when it comes to whether something is unconstitutional or not. But if you think that a lower court should not say that the government has been acting unconstitutionally, well, that's a question of whether we allow administrative cases to be handled of this nature to be handled by the court, and we're told that the matter should be referred back to the MPC. If we have an external power always there to offer criticism of the judiciary will be undermined. The judiciary performed very poorly during the occupation movement. It allows someone other than it allowed the government to apply for an injunction, or it allowed a non-government party to apply for an injunction instead of asking the government to exercise her rightful powers. Ms. Choi, I'm no lawyer. I just think that is unreasonable. Mr. Leung, what is your question? My question is, don't tell me that you want a pay rise. Please just specify the separation, the boundaries, and the delineation of the powers and the separation of powers. People don't want to be judges, not because they don't get good pay, but because there's no honor, no glory. So the improvement should be made to areas other than pay. All right, so Mr. LegCo Hon has just offered some comments. There's no need to answer. Thank you, Chairman. Mr. Albert Ho. When it comes to the pay adjustment mechanism for judicial officers, I support it. I support the separation of the system from that for executive branch to ensure the political neutrality. When there was pay cuts, we did not agree that the same should apply to judges, and we said the judiciary should be kept separate. For this exercise, this pay adjustment exercise, I have no comment, and I support the adjustment. I don't think you have consulted the judges. I don't think they have strong views. When the judiciary wrote to the government saying that they would like to get a pay adjustment of 4.41%, I believe that was a result of some internal discussion or consultation on their part. Still, I'm concerned about the vacancies. It's 11% plus. Some courts have very heavy workload. And how can you tell? Well, if your case cannot be completed within one hearing and has to be resumed later, it's difficult to get another listing date. So there may be a wait of weeks or months. And I have personal experience. And some judges have to read documents outside their work hours. I know that there's no standard working hours as such, because they may have to do a lot of reasoning. It's still easy to give a judgment, but you have to properly set out the reasoning. In some cases, the judgments has to wait for 6 months to a year. I, as a lawyer, have encountered such cases. If the judge has no time to write the judgment and the parties have to wait for 9 months, and in the meantime, the judges are still hearing cases, and when the judge finally has time to write the judgment, can he really remember all the details? In a case, the judge mistook the plaintiff, the accused as the plaintiff, and then he also make a very big mistake and said the accused was acquitted. Or the talent pool comes from internal promotion or from barristers in private practice. In the past, we had very good Queen's Counsel coming over, but not anymore. So do we have to reconsider the bilingual requirement? And that's why you don't want to recruit overseas judges? And also there's the question of housing and accommodation for overseas judges. Thank you. many of the points made are about the internal operation of the judiciary, and I may not be the best person to answer the questions, but as far as I know, when it comes to workload, in the paragraph 3 of the paper we have given to this council, the Judicial Committee has noted that in the past few years the workload of the judiciary remained steady, but the complexity is on the increase. It's getting more and more complex. And sometimes a relisting will be required for a complex case, and the workload of the judge is therefore heavier. On recruitment, as far as I know, it's not restricted to Hong Kong. The recruitment notice is also published in overseas jurisdictions. In the past 4 years, there were 81 appointments of judges and judicial officers, and 41 were filled from outside barristers or lawyers, and 31 from their own internal promotions. How about overseas practitioners? Not for the moment. But the recruitment exercise is not restricted to Hong Kong. Chairman, you are a lawyer. You know that even after the reunification, there were quite many overseas lawyers coming to Hong Kong to serve as judges. So we were able to do that. Why not now? And it's not a policy of not offering appointments. Is there any exclusion practice? Is there a question of language? Because you want to have bilingual judges? Well, I don't think I can answer the questions on behalf of the judiciary. I can relay your questions to the judiciary instead. Please give us a reply in writing. And in some cases, the judgment is delayed for up to 6 to 9 months after the trial. A question was asked in May. We discussed judicial manpower in May. We asked overseas applications for CFI judges. We haven't received a reply, right? And through you, I did ask for some figures. And that is in how many cases the judgments were only provided after 6 months or more. It was not through me. You did raise this through the previous chairman, right? Well, I did ask for some figures. Perhaps I should raise the question again. Please give us figures. Because we have received inquiries. We're not complaining. The judiciary is working very hard, and their job is difficult. But you know that the judgment, the delay in handing down judgment is going to cause fairness problems. Maybe I can ask the clerk to see if we have received the information. And if so, the information can be disseminated. The clerk is sure that there was the question raised in a previous meeting. But maybe we haven't received a reply. Let's see if we can find the reply now. If not, we'll put the question again. It's a matter for the judiciary, not for the executive. Mr. James Low, I want to follow up a question on the retirement age. You said a study has been commissioned, and you find a consultant. I don't understand why. Yes, you rely a lot of such. You rely on the consultant on a lot of such matters. But I don't think the consultant will be more knowledgeable about the situation than judges, unless we have a judge who had just retired. For instance, Mr. Andrew Lee. I'm not saying he is a consultant. A retired judge will be the best consultant in my view if he's willing to take on the job. I don't mind paying the fee for the consultancy, but actually the consultants would be sending out questionnaires to the judges and to ask questions around. You might as well ask one of the judges to do it instead. Unless we have a consultancy firm set up by retired judges. Otherwise, I just don't understand why you should hire a consultant. Unless they have special expertise. Or are they really consultancy firms set up by retired judges who are allowed to take on the assignment after getting some approval? And I certainly agree that judicial assistants can help. There's no need to have a consultancy study. We can see that from foreign jurisdictions. I hope the judiciary would do more. Director, can you tell us why the judiciary requires a consultancy study to look into the retirement age? I cannot really answer this question on behalf of the judiciary. The consultant was commissioned by the judiciary. Well, there's the judiciary administrator, and the JA is a senior AO. So please relay our question to the judiciary. Mr. Dennis Kwok, second round, 3 minutes. I don't need that much time. I think we should invite someone from the judiciary to come over, because Ms. Choi will only be involved in the pay adjustment. But this is exactly the item. But we have questions about the operation and the recruitment of the judiciary, which are closely related to pay adjustment. Next time, we should invite someone from the judiciary to join us, instead of asking Ms. Choi to relay our questions to it. Mr. Albert Ho, the question was you mentioned was raised on the 16th of October. We have yet to receive a reply. Maybe it takes some time. Mr. Leung Kok Hong. Well, remuneration has to do with the job, the duty. If you think that the workload is increasing, the duty is getting more complicated, well, then I think you should provide assistance to judges. I heard of a case that some justice of appeal asked a master to hear cases for him. That's inappropriate. if an inappropriate arrangement has been put in place in the judiciary to help the Court of Appeal, then the proper way out should be to provide some appropriate manpower to help the judges instead of asking the masters.
So you have to think about that too. And this is related to the pay rise, but because it's meaningless to give 4.4%, the 14.4% in our system, perhaps that should be proper in providing the assistance to the judges rather than to delegate the case to another judge or another person, because there are privacy issues and a lot of other sensitivities as well. Now, I've actually written in, and you've tried to answer me time and again to no avail. And another point, which I'm very concerned about, is that it is rather indiscriminate now, and that is the legal department or ex-officers of the legal department. And I know of someone who is in the track in the judiciary. I think this is inappropriate. I'm not saying he as a person is problematic, but rather for a person to be in the legal department and to be serving as a judge later on, I think there may be clash of interest suspicions. I mean, at least there are such sensitivities. I mean, I'm sure the person in his new position would know his colleagues in this office as well. Now, of course, he was a prosecutor. That's his job. That's his career. And every minute of his time was devoted to prosecution, get somebody convicted. And that is a built-in psyche, you see, and that is quite unacceptable. And for someone so significant as this, a person like that to sit as judge, I would be highly worried if he's sitting in my case. Chang Lai-wan? Mr. Chair, a couple of questions. The first one, concerning 4.41% pay rise, I have no problems with that, but rather I'm thinking about the senior officers and directorate, the civil service pay rise of 3.96%. I would like to know, in the past, had the judiciary followed this? That is, this index set by the civil service, or whether they always had their independent adjustment? Because I had another meeting. I do not know whether this question's been asked before. And another issue, now if there were adjustments, and you're saying that the committee will not consider this until next year, so when exactly will be the revision implemented? For the civil service, it's already come to pass. As for this pay rise, it is still in process. Will this be delayed for 2 years, 3 years? And if so, is that fair? And another point, very often we take the market into account and the need for resources when we think about pay rise. Now, I heard just now that my colleagues were asking about recruitment, training, nurturing. How do you train up your judges? Will there be more local judges trained up, etc.? So my question is, because this is the executive today should not be the party to answer our questions today, but would the judiciary perhaps should be present so as to answer these questions? Yes, Ms. Cheung, yes, indeed, the questions you asked just now have been answered in part. Perhaps Ms. Choi, again? Yes, Mr. Chair. First of all, about the trend of the pay index. Well, actually, for the civil service and the committee for the judiciary, they have both referred to the private sector pay index, which we have mentioned in the paper is 4.46%. But then they have to deduct from it the total expenses from the master's pay scale, which was 1% for civil service, and therefore the rise is 3.46% for the civil service. As for the judiciary, overall expenses for pay rise is 0.55%, and therefore after deduction, their net index is 3.91%. So basically, it is the same basis of foundation. However, the net deduction is different. Now, and Ms. Cheung, you said you're concerned about whether this will be dragged on for a couple of years in implementation. Now, that will not be the case because the committee is already doing a survey about pay in the profession, and they very much want the result of this to be in time for 2016 pay rise implementation, so that the results will be gleaned before then as reference for the pay rise. And the survey, as far as I know, is already in progress. And after this had been completed as an exercise, the consultant will have 15 to 20 face-to-face interviews, solicitors, barristers, so that they will know the changes to the pay rise and also their views concerning the pay. Mr. Chair, I would like to know whether this had happened before. That is, the pay rise between the judiciary and the civil service had been different, and whether it had already happened that the judiciary had an independent exercise, or whether the two had been the same. Well, the last round was 2010, and a consultant was appointed, and also the two bodies, the Law Society and the barristers, have also sent out a questionnaire asking questions about their pay in the profession. And very interestingly, what came out was that the pay was not the main determinant as to whether a legal person would want to join the ranks of judges. And in different ranks of lawyers, such as magistrates, district courts, and court of first instance, different levels of judiciary officials, the discrepancies in their pay compared to the private sector, some exceed the private sector, some fall short of the private sector pay. So there was no consistent trend as such. Are there other questions? There being none? Yes, yes. Excuse me, Mr. Chair, just one other question. Now, if the result of the survey, if it comes out that the private sector is higher than the judges in our judiciary, then it is possible that there will be adjustments. What if it is lower? What then? Mr. Chair, thank you. I cannot answer that question on behalf of the Judiciary Committee to say what if it falls short or it exceeds the private sector, what then? But in fact, before they did this survey and study, they said that the study cannot be be distilled into a particular figure. What they're trying to find out is whether over time the discrepancy between the two is extended or contracted. That is the difference between the judiciary pay and also private sector pay. So after the results come in, they will have to do a very prudent and detailed decision before there can be any a study before there can be a decision. Even though this is all about pay adjustments, but in fact, as mentioned by the colleagues, there are a number of issues which have to be taken into account as well. So in the next meeting, perhaps the judiciary should also send representatives as observers or to participate in the meeting. That would be more appropriate. Well, actually, Chair, we have some reservations in this regard because the judiciary, on this particular topic, they have a demand on pay rise. So, and what we put in front of the members now had already gone to the Executive Council, the CE in Council, and the government is already in support. Basically, we're looking for the support of this panel. Now, if the judiciary is to be put into the same meeting room, and I would think there may be certain conflicts in roles. Oh yes, in that case, we'll think through, because the panel, in considering this, will also have to consider a basket of factors, just as the Judiciary Committee had considered a basket of factors. I think we'll have to think through before we decide on what to do next. Third round, 3 minutes, Ms. Chung. Mr. Chair, I just wanted to say that the administration wing wants us to support this pay rise. And of course, I think there should be a pay rise. But Mr. Kwok and I have both expressed concern about the recruitment, training, and nurturing of judges locally. And that may not be the terms of reference of the administration wing. And I think the judiciary should, at a different time, a different place, come in for discussion. So there will be another business for future discussion.
Members, do we support the government's proposal to submit the proposal to the FC? No objection? Ms. Zhang, you object? Well, I just want to raise my hand to give my support. So we all support the proposal. It's unanimous. So the item will go to the FC. We move on to the next item. Law Reform Commission's consultation paper on third-party funding for arbitration.
sorry， 我想趁呢個時間呢，因為我驚遲啲啲人走晒嘅。
I'm concerned that there will be too few members remaining. Well, from the Chief Justice, there's an invitation to the new CFA building, and that is the old one, which has now been renovated and refurbished, and also to exchange views on matters of mutual concern. So you will have a chance to talk to Chief Justice, Mr. Ma. There are a few optional days. 18th of January or 25th of January, both in the morning. So we'll issue the invitation to members. Please reply as soon as you can. I'd like to invite the Law Reform Commission third-party funding for arbitration subcommittee, Ms. Kim Rooney, to introduce the paper.
I'm not quite sure how to work this. Sorry, it's Ms. Rooney.
Ms. Rooney.
Thank you, sir. Good afternoon. Mr. Martin Lau, Chairman of the AJLS panel, members of the panel, thank you for giving this opportunity to the Hong Kong Law Reform Commission's Subcommittee on Third-Party Funding for Arbitration to discuss with you our consultation paper published on 19 October 2015. The subcommittee is represented today by Mr. Victor Dawes, SC, a member of the subcommittee, and myself, its chair, attending with Ms. Michelle Ainsworth, Secretary to the Law Reform Commission, and Ms. Kitty Fung, Secretary to the subcommittee. On behalf of the subcommittee, we would like to speak with you about the reasons for the establishment of the subcommittee, the recommendations of the subcommittee contained in its consultation paper, the consultation period that ends on 18 January 2016, the process of finalising the subcommittee's part of the work on this reference, and to answer any questions you may have at this stage. Third-party funding has been defined as being the funding of claims by commercial bodies in return for a share of the proceeds. It is a non-recourse form of funding. That is, if there's no recovery from the funded proceedings, the third-party funder will not receive any repayment or return. Users of arbitration taking place in Hong Kong are overwhelmingly corporations, partnerships, government departments and similar entities. This is reflected in the types of disputes that are commonly resolved by arbitrations taking place in Hong Kong, whether of an international disputes or disputes that have arisen in mainland China or in Hong Kong. Hong Kong is one of the world's major centres of international arbitration, as recently confirmed by an independent survey conducted by Queen Mary Law School in London and an international law firm. May I just refer you, honourable members of the panel, to the terms of reference. In early 2013, the Chief Justice and the Secretary for Justice asked the Law Reform Commission to review this subject. The terms of reference of this subcommittee are to review the current position relating to third-party funding for arbitration for the purposes of considering whether reform is needed, and if so, to make such recommendations for reform as appropriate. The subcommittee was established in June 2013 and its members consist of the following: myself as chair, as a barrister, Ms. Teresa Cheng, a barrister and the chair of the Hong Kong International Arbitration Centre, Mr. Justin D'Agostino, Global Head of Dispute Resolution Practice at Herbert Smith Freehills, Mr. Victor Dawes, SC, barrister, who's here today, Mr. Jason Carras, Principal of Lipman Carras, and Mr. Robert Pang, SC, also a barrister. Ms. Kitty Fung, also here today, a Senior Government Counsel in the Law Reform Commission Secretariat, is the Secretary to the subcommittee. We've met regularly since our formation to discuss the matters within the terms of reference. The recommendations in the consultation paper are the result of these discussions. They represent the subcommittee's preliminary views and are presented for consideration by the community. Now, if I may go back to third-party funding for arbitration, this has become increasingly common over the last 10 years or so in many jurisdictions where arbitration is conducted, including in Australia, England and Wales, Europe and the United States, as well as most jurisdictions in Asia. The subcommittee has reviewed Hong Kong law and also the law of 12 other jurisdictions around the world where arbitration is conducted regularly. Nearly all major international arbitration centres now allow third-party funding for arbitration, and in the one we've come across that does not allow it, they are reported to be reviewing whether they should permit it. It is likely that a party to an arbitration taking place in Hong Kong may wish to consider whether it should seek third-party funding of its arbitration. But one potential obstacle to Hong Kong maintaining and growing its role as a leading international arbitration centre that's been identified, and which is the subject of the work of this subcommittee, is the current uncertain state of Hong Kong's law as to whether parties to an arbitration taking place in Hong Kong may obtain funding from third-party funders to finance the cost of their arbitration. The cause of this uncertainty is the unclear application to arbitration taking place in Hong Kong, and I'll come back to why I keep saying that, of the legal doctrines of maintenance and champity. These were developed some 700 years ago in England to prevent unnecessary proceedings being promoted or financed by powerful individuals for the sole purpose of furthering their own interests. Now, the Hong Kong courts have held that these legal doctrines of maintenance and champity do still apply, but there are 3 exceptions which I'll come back to. However, the Court of Final Appeal has observed that the scope of what constitutes maintenance and champity in Hong Kong has been narrowed over the years, reflecting the changed public policy considerations to allow recognised exceptions. I mentioned there are exceptions. Now, what are these exceptions in litigation? They involve their cases where there are third parties with a legitimate interest in the outcome of the litigation, or where there are access to justice considerations, or in a miscellaneous category, including insolvency litigation. However, it's unclear whether these doctrines of maintenance and champity also apply to third-party funding for arbitrations taking place in Hong Kong. And this may be seen from the judgment of the Court of Final Appeal in 2007 in a case Unruh and Seeberger. There the court said they upheld the validity of a third-party funding agreement for an arbitration which had been conducted outside Hong Kong in a jurisdiction that did allow third-party funding of arbitration. In other words, they said arbitration took place outside Hong Kong in a place where third-party funding is allowed. That's okay. But the court expressly left open the question of whether the doctrines of maintenance and champity apply to third-party funding agreements for arbitrations taking place in Hong Kong. There was a 1994 decision of Kaplan, or Justice Kaplan, where he said the doctrine of champity didn't apply to arbitration. However, Unruh and Seeberger, the Court of Final Appeal in 2007, expressly left this question open. The uncertainty in Hong Kong law as to whether third-party funding for arbitrations taking place in Hong Kong is permitted is leading to a general view that it's not permitted. This potentially makes Hong Kong less attractive as a place in which to conduct arbitration and damages its competitiveness as an arbitration centre, whether for international arbitrations or disputes arising in mainland China or Hong Kong. Why does it make it less competitive? Because parties can get third-party funding in other competitive jurisdictions. The subcommittee has observed that third-party arrangements are usually motivated by a party's lack of financial resources, but sometimes parties also use it as a risk-sharing measure or to reduce their outgoings. Now, if I may, honourable members, may I just go to unanimous recommendations, which, as we've said, are preliminary. We respectfully have recommended that Hong Kong law that we recommend that there should be reform of Hong Kong law to make it clear that third-party fundings for arbitrations taking place in Hong Kong is permitted under Hong Kong law, and provided that appropriate financial and ethical safeguards are complied with. From our review of the law in Hong Kong and 12 jurisdictions around the world, we have seen there are obvious benefits, we respectfully say, of third-party funding for the parties in arbitration, those who provide services, and for the general community. And the committee has concluded that the reform of Hong Kong law to clearly permit third-party funding of arbitration with these appropriate safeguards is necessary to maintain and enhance Hong Kong's competitive position as an international arbitration centre, to avoid Hong Kong being overtaken by its competitors, and to continue to provide service to arbitration users in accordance with best international standards tailored to Hong Kong's needs. We respectfully have concluded that a party with good arbitration case should not be deprived of financial support it needs to pursue its case, for example, small and medium-sized enterprises. And if parties can't lawfully obtain third-party funding for arbitration in Hong Kong, they may well choose to arbitrate somewhere else where they can get such funding, which, as we've found, is nearly all of Hong Kong's competitors. But to protect against potential abuse of third-party funding, we consider that appropriate ethical and financial safeguards can be placed on third-party funding of arbitration taking place in Hong Kong. So we believe that such reform would be in the interests of arbitration users and of the Hong Kong public, because of the public's interest in fair and efficient arbitration, access to justice, more arbitration-related employment, skills enhancement, revenue from arbitrations, diverting more commercial, construction, finance, trade and similar disputes from the Hong Kong courts to arbitration, which will relieve pressure on the Hong Kong courts' resources, and, as we've said, supporting the competitiveness of Hong Kong as an international centre for arbitration. Such reform would also be consistent with the relevant principles the Court of Final Appeal has formulated in its 2007 judgment in Unruh and Seeberger, and a later judgment in 2012. In the discussion, the consultation paper, we have always borne in mind the public interest in the fair and efficient conduct of arbitration and access to justice, among other considerations. Now, Members of the panel, we've issued this consultation paper to seek the public's view and comments on whether reform is needed of the current position relating to third-party funding for arbitration in Hong Kong, and if so, what kind of reform is appropriate. The consultation period will end on Friday, 18 January 2016. All public submissions, which are greatly welcomed, will assist this subcommittee to reach its final recommendations that we'll submit in a draft report to the Law Reform Commission for their consideration. As you know, the Law Reform Commission will then finalise and issue the final report on third-party funding for arbitration, incorporating such amendments as it considers to be necessary. There's no set timetable for this, but this subcommittee will complete its work as quickly as it can and submit the final draft report as soon as possible, having reviewed all submissions received and amended as necessary the recommendations contained in the consultation paper. And now, very briefly, I'd like to just go to those recommendations, which I believe you have in the executive summary. The first recommendation is that we recommend that the arbitration ordinance, the law that provides for the framework for arbitration in Hong Kong, should be amended to provide that third-party funding for arbitration taking place in Hong Kong is permitted under Hong Kong law. Our recommendation, too, is that there should be clear ethical and financial standards for third-party.
第二個建議就係我哋建議嗰啲提供第三資助喺香港進行仲裁嘅當事人同埋第三方嘅出席者呢，係應該定清晰嗰個專業守則嘅標準同埋財務標準嘅。同埋呢，我哋邀請公眾呢就。
There is little uniformity in the form of regulation applied. Our study shows that the main trend in overseas jurisdictions is towards a light touch approach to regulation, either by statutory regulation of financial and conflicts issues, for example, Australia, or by self-regulation, for example, England and Wales, where the Code of Conduct, which is referred to in the executive summary, the Code of Conduct for litigation funders was published by the Civil Justice Council, an agency of the UK's Ministry of Justice, in November 2011, and it's since been amended, and the Association of Litigation Funders has been given the responsibility of administering self-regulation in line with the Code. In all the jurisdictions reviewed, the courts continue to play an important role, and there are ethical and professional rules imposed on lawyers of varying content. We consider that Hong Kong should develop its own model of regulation of third-party funding to suit its culture and needs, which will be informed by the experience and approach of other relevant jurisdictions. Now, as to recommendation 3, which concerns the form of regulation of third-party funding in Hong Kong and the matters to be regulated, the subcommittee doesn't have any fixed views as to whether the approach to be adopted should be statutory by a law or such as by a schedule to the arbitration ordinance, or by a code of conduct, such as been done in England and Wales. There are potential challenges in adopting either approach, and we've outlined these at paragraphs 6.8 to 6.11 of the consultation paper, and we've therefore invited submissions from the public on this area. Obviously, the areas that should be reviewed for regulation are important, and you'll see that we've discussed these as being capital adequacy requirements, conflicts of interest, confidentiality, privilege, control of the arbitration by third-party funders, disclosure of third-party funding to the tribunal and also to the other parties to the arbitration, termination of funding, and complaints and enforcement procedures. Given Hong Kong's very special situation, 2 additional issues have been discussed by the consultation paper. The first is the extent of the extraterritorial application of any framework. How far should it extend? Because this often with arbitration, even if the arbitration is taking place in Hong Kong, there will be aspects of it being done overseas, so an extraterritorial issue often arises. There are also potential problems for lawyers working on an international arbitration in Hong Kong that has its legal place in another jurisdiction where third-party funding is permitted. And then also we've looked at the question just in a preliminary way, if it is decided there should be self-regulation, which body should issue the regulatory standards, and we've set out a possible approach. Thus, in the consultation paper, we've invited submissions on how the applicable, and we've also asked in the consultation paper how the applicable ethical and financial standards should be enforced. And then finally, it's a fairly specialised area, but we've also in recommendation 4 raised an issue of whether or not the tribunal should be given power to make adverse costs orders and security for costs orders, and we've explained what they are, but perhaps at this point I may thank you again on behalf of the subcommittee for giving us a chance to discuss this with you. Mr. Dawes and I are available to answer any questions you may have or to respond to any comments on the consultation paper, and Ms. Ainsworth and Ms. Fung are available to answer any more general questions on behalf of the Law Reform Commission. Thank you.
Thank you, Mr. Rooney, for the presentation. 副主席。
Vice Chair.
That I've been pushing for this arbitration funding for a number of years now, so I welcome the recommendations of this report, especially when Singapore doesn't do it, that we should be seen as the jurisdiction in Asia doing this arbitration funding. Ms. Rooney, you would know that actually for some arbitrations in Hong Kong that is now taking place, there is arbitration funding going on. So does the Commission have access to, or do you have any idea as to what extent arbitration funding already takes place in Hong Kong? And you know there are UK funders that have just established an office in Hong Kong. So it is going on. So let's not pretend it is something completely new that we don't know how it works. So my first question is, does the Commission know to what extent does arbitration funding goes on in Hong Kong, how they're done, and what is the market practice? That's my first question. My second question is the timing of the proposals, because you recommended that the arbitration ordinance should be amended. I agree that is the best way, but you know how the government works. Your report sets out the recommendations, but it takes them 10 years to get round to amending the arbitration ordinance. We're going to lose our edge. Is there a better way of doing it? Is there a faster way of doing it? Is there a way to, say, bring a test case to the court to, get a ruling on this point? Would that be a faster way? Because the court can rule on this point to say whether arbitration funding is permissible under Hong Kong law. It is regrettable that Ribeiro PJ didn't rule on this point in the Seeberger case, but would that be a better way? My second question.
Ms. Rooney.
Thank you very much. In terms of the first question, do we know to what extent litigation funding is underway? I will start answering it, and I'm going to invite my colleague, Mr. Dawes, to keep answering it. We actually had arbitration week in the last week of October. Why do I mention that? Because a lot of these funders seem to have come to Hong Kong for that. They all said that they were engaged in funding insolvency litigation, which falls within one of the exceptions. They said that even though some people in Hong Kong think because of the decision of Justice Kaplan of '94 it should be fine to fund arbitration, there is a question mark. So I can only comment anecdotally that I was informed by these funders that they're focusing on the areas where it's clearly permitted. But may I invite Mr. Dawes to comment?
I think Mr. Kwok's assumption must be correct. We can't pretend that it is not happening. But I think everyone seems to be doing it in a rather coy way. It is almost impossible for us to gather market data. I mean, from discussions that we've had with funders, I think we get the feeling that something's going on. So I think to answer your question directly, from official channel, it's just impossible to gather statistics in this regard.
Thank you. And in terms of the second question, forgive me if I've skipped any, whether or not there's a quicker way. We're approaching this as lawyers, and we have already reviewed Hong Kong law, and as you've observed, Mr. Kwok, the Court of Final Appeal in 2007 left this question open, and in another case I think has said there are issues relating to this area that need to be addressed by law reform. So from our perspective, it seems that the most effective way to clarify the situation is to respectfully suggest the arbitration ordinance should be amended if that's feasible. I don't know if anyone else on this wants to comment.
To respond to the question directly, of course, having a test case would be one of the possibility, because the uncertainty is, of course, A, whether they would duck the question again, B, whether the test case would actually solve all the issues that we have considered. And of course, it is something that is not possible for us to control. So I think that's where the difficulty is.
Yeah, I was just thinking the role of the arbitration centers in Hong Kong. For example, the Hong Kong IAC surely must have an interest to know the legal position, because they are, although not direct parties, they're indirect parties to these agreements. If they know they exist and they administer these arbitrations in Hong Kong, so they have a role to play. So it is in their interest to have this legal question clarified. So maybe you can speak to them about this suggestion. But I agree with your recommendation that the best way is to amend the AO. But I'm just concerned that it will just get bogged down and nothing happens for 5 to 10 years. That's the last thing we want to see.
Okay, thank you. 下一位係蔣麗芸議員。
Ms. Zhang Lei-wen. Thank you, Mr. Chair. Concerning third-party funding arbitration, it is much like, well, previously in Hong Kong we have all looked into an issue, and that is the maintenance and champerty. But it is not legal in Hong Kong. The doctrines of maintenance and champerty is not acceptable in Hong Kong at present. So when we're looking into third-party funding for arbitration, would it not be that similarly it would also contravene the same things, that is maintenance and champerty in Hong Kong, which is disallowed? But I think, in fact, there is a fine distinction. In the main, arbitration, ordinarily speaking, because Hong Kong does have the International Arbitration Center, and I just heard Ms. Rooney saying that at present some of the overseas countries already accept this third-party funding for arbitration, including the UK. I heard UK just now. It is already in practice, third-party funding for arbitration. Now, if there is, Hong Kong doesn't allow this at present according to our laws. However, if there are certain behavior where, that is to say, there is a third-party funding in another jurisdiction, and for the case to be heard in Hong Kong Arbitration Center. So there are two parties to the arbitration. The two parties use Hong Kong Arbitration Center as the venue for arbitration, but respectively for these two parties in their own countries, they are funded by a third party. And this kind of funding behavior in their respective jurisdictions are allowable. Now, if these two parties come to Hong Kong for arbitration in Hong Kong, will they contravene our laws? How do we look upon this?
Thank you very much, Madam, for your question. That is a question that highlights what the problem is, because these lawyers may be working in jurisdictions and the parties are based in jurisdictions that allow third-party funding, but that arbitration in the scenario you've mentioned is one where the arbitration takes place in Hong Kong. And a straightforward approach to it is that Hong Kong law doesn't allow third-party funding of arbitrations taking place in Hong Kong, or there's a question mark about it. That's one of the reasons I understand that this subcommittee was established, because of the very situation that you've just mentioned, the possibility of that.
Mr. Chair, arbitration in Hong Kong, usually it is basically commercial disputes go for arbitration in Hong Kong. I would like to know, for our Law Reform Commission and the subcommittee, I would like to know whether you have considered, in terms of third-party funding for arbitration, have you consulted the chambers of commerce on this?
Thank you again for that question. We are now consulting them through this, as we are everyone in the public, through this consultation process. We have not had meetings with them prior to issuing the consultation paper. But of course we would welcome very much any comments that they may wish to make, along with other members of the public. Victor, do you want to add something?
Yeah, 我諗我回答返蔣議員之前嗰個問題。
Perhaps I can answer Ms. Chang's question concerning maintenance and champerty. It is slightly different from the area that we are studying, the area of study by the subcommittee. As you mentioned just now, for the majority of the cases are commercial disputes in Hong Kong. Of course, there are some participation of SMEs and multinational companies as well. And perhaps you are more concerned about the cases that are dealt with in the law courts. That is to say, there are some injuries and cases which are more sensitive. That is, you might be thinking of the disadvantaged parties which are involved in such legal cases. And the administration's stance is that perhaps those are not most urgent in terms of need for reform. But for commercial cases, disputes, arbitration, that's where we focused on.
Please wait for your second round. Mr. Tan Ka Piu, I also want to ask a question about the scope. Well, paragraph 47, arbitrability. Commercial cases, collective class action, but we don't have anything on class action yet. So maybe we can provide third-party funding for arbitration in respect of consumer cases. No, we are not talking about litigations, Mr. Tan. We don't have class action. So when we have a third-party funding for arbitration, would you cover consumer complaints cases? As cases between consumers and companies? Or employment cases, medical negligence cases? Are you going to exclude all these personal cases because you want to concentrate on commercial cases? If so, how can you do it? Or are you saying that the coverage may extend to such cases? And arbitration is different from courts. Courts enjoy the tenure for life, but arbitrators, well, they are, I believe, lawyers. Who are the arbitrators? The parties may be represented by lawyers, but would the arbitrators also be lawyers? Are they arbitrators enjoying life tenure? And also that leads to the next question. Why is Singapore not doing this? Is it because of the concern about the conflict of roles? Or for some, on this occasion, I'm a lawyer. On the other occasion, I'm an arbitrator. Ms. Rooney.
I
think I can answer the first part. What will be covered by arbitration? I think lawyers know this. It depends on the parties' arbitration agreement. You mentioned consumers, employer-employee disputes. in most cases, they don't have an arbitration agreement. So that's why they have to go to the court. Why do we want to concentrate on commercial disputes? Because in many cases, they have an arbitration agreement. So this is a causal relationship issue. We cannot really be so selective as to which cases would go for arbitration. It's up to the parties and whether there's an arbitration agreement. I'll ask Ms. Looney to talk about the lawyers vis-a-vis arbitrators. She's a very senior arbitrator.
Thank you, sir. I hope I've understood the question correctly about the... I understand that part of your question on lawyers was whether or not sometimes people act as counsel and sometimes they'll act as arbitrators, and whether that can give rise to a conflict of interest, I guess. And it is something that in the arbitration community there is a lot of discussion about. And generally people tend to do over time more of one thing, that is being an arbitrator, or another, being a counsel. And there are very strict rules. Of course, rules don't always work, but there are very strict rules about avoiding conflicts. I'm sorry if that's not a complete answer. You've identified one of the issues that's often discussed about arbitration, but there are strict rules to avoid conflicts. In terms of Singapore, which you've mentioned, there have been reports recently, sir, that Singapore is also reviewing their law in this area. Why? The reports are for similar reasons to why Hong Kong is. That is the issue of maintaining competitiveness. And they've... Sorry.
Sorry, 我聽到。因為會唔會新加坡
Well, I'm just speculating. I don't know anything. Maybe it's because Singapore is so small. If I had a third-party funding and the legal representatives maybe acting as an arbitrator and as counsel or legal representative at some other time. It's because they are so small, they want to avoid such conflicts.
May I just comment on that, sir? I can't comment on all the factors that influence the law in Singapore, but my understanding, and it is one of the jurisdictions we looked at when preparing our consultation paper, is they also maintain the application of the doctrines of maintenance and champity, and so to that extent have taken fairly strict approach to where the circumstances in which third parties may fund litigation, for example. But recently they have had a case which said, yes, you can fund litigation and insolvency. But arbitration, the statement is not permitted now, but reports that it's being reviewed.
係蔣麗芸議員第二輪3分鐘。
Ms. Ann Jiang, the second round, 3 minutes for questions and answers. I think third-party funding for arbitration is more applicable in the commercial world, to the commercial sector. If we have the reform, if the Law Reform Commission wants to take things forward or to conduct further consultation, I think the Commission should talk to the major chambers of commerce in Hong Kong first. I believe by doing this, you would face less resistance. And you may also wish to consider some adjustments after you have heard from the chambers of commerce. That's what I want to make as a suggestion today.
I have a question. The doctrine of maintenance and champity has existed for hundreds of years, and there are evils guarded against by the doctrine. And I think, whether this can go forward or not will be one of the major concerns of of a lot of the legislators, whether the abuse of the system can be regulated and enforced. whether you have any teeth in your regulatory framework, whether it's just a toothless tiger or whether there is actual salutary effects in that enforcement mechanism. I think that would be an important consideration, at least for me anyway. The concerns of Singapore in relation to this will be, I think, echoed when the matter comes forward, for legislation. I think that's something that the subcommittee ought to bear in mind. Thank you.
Thank you, sir.
Is there anything else you would like to address the committee?
No, I don't think so. Thank you, sir.
Okay. Well, thank you very much for coming.
Thank you very much. Thank you, members.
Okay, 咁我哋
I think we have completed all items. We have already handled AOB, so meeting's adjourned.